let's go to 110 and 111. Counselor, you're on. Would you like any rebuttal time?
Yes, if I could have 3 minutes.
3 minutes? Go ahead. This is Washington, right?
Yes, sir.
Go ahead.
Your Honor, I'm Camila Zaraga from Weil Gottschall, and I represent Kareem Washington, the appellant, in association with the Office of the Appellate Defender. In this case,
what was done wrong in your case in terms of this whole idea of what the defense counsel did vis-a-vis the defendant? What undercut the defendant in the counsel explaining what happened? He's not saying deny the motion, saying this is what happened. What's wrong with that? And how does that play into our case law in this area?
Your Honor, counsel in this case said several things that were adverse to his client's factual allegations of ineffective assistance.
Well, is he allowed to explain what happened from his point of view at all?
He was responding to judges' questions, too, wasn't he?
Your Honor, yes. The court in this case did ask counsel if he wanted to address the remarks. But Mr. Washington set forth on the record in this case that in 2.5 years of representation, leading up to a felony trial with potentially a life sentence, a 20-year to life sentence mandatory minimum, his lawyer did not meet with him, only spoke to him once, did not consult with him about strategy, and did not reply to his responses to discuss strategy.
But the judge listened to all of that,
yes.
Listened to the counsel say, at least from his perspective, what had happened, looked at his own observations, and then made a decision. What's wrong with that?
What's wrong with that, Your Honor, is that counsel staked adverse positions, including saying there are incorrect things in this motion. I am sure I did discuss strategy with Mr. Washington. I did give him discovery.
What should the counsel do? Just say nothing?
What counsel should do is, under Mitchell, counsel can often explain his performance unless it amounts to an adverse factual or legal position contradicting his client's claim of ineffective assistance.
Is that our law or federal law in terms of what's an adverse position? Is it adverse in differing on a material fact?
Your Honor, the standard is...
In New York and the standard in the feds, isn't there a difference?
I'm not...
In the federal standard versus ours, in terms of a disagreement as to a material fact, is it an actual conflict in New York to disagree on a particular...
Yes, Your Honor. In New York, under the Court's precedents in Lewis, in Vasquez, in Baroa...
Let's get to this. If the defendant says he never met with me in 2.5 years, and the lawyer says, I got my time slips, I met with him every 3 weeks, can he bring that in? That's adverse to his client.
That is adverse to his client, yes, Your Honor. And a court, when faced with one of these motions that makes an allegation of ineffective assistance, it should question the defendant in detail.
Can he say that? Can the defense lawyer say, here are my time slips, I actually did...
No, he cannot say that, because that is an adverse position to his client. It's adverse testimony.
You're saying the defendant can lie, and the lawyer has no right to contradict him.
I'm not saying that the defendant can lie. I'm saying if the court is put in...
If the defendant lies... Can the defense lawyer correct the record to say, yes, indeed, I did visit him every 3 weeks?
If the court is going, if counsel is going to correct the record by contradicting his counsel's factual allegations, then he is putting himself in a position as an adversary in court. He can do it.
Can he say he's lying? Here are my records. I met with him every 3 weeks. Yes or no?
No, he cannot without contradicting his client.
There's a little complication on the record here, though, isn't there? Because there was this time period between when the motion was actually submitted and when the court actually received it. So it was submitted several weeks before trial, and the court didn't address it until after the trial.
Yes, Your Honor.
And you know, can the record be read so that it actually isn't contradictory, so that the defendant was saying, up until the time I submitted this motion, none of these things had occurred. And then the lawyer came back and said, I mean, he didn't specifically say this, but I think that there's a reading of the record that would support that he said, well, after the motion was submitted, I did do all of these things, and the defendant didn't complain about anything that happened at trial. So is that So could it be read as that there really wasn't a conflict here?
Your Honor, the record in this case cannot be read that way. It is true that there were developments after the motion was filed due to this glitch, this court error, where the judge did not receive it.
So couldn't the judge have then looked at that and said, well, you know, okay, maybe the attorney didn't do these things up until that point, but he eventually did. He gave effective representation at trial, and, you know, and there's no issue here.
Well, there are a few issues tangled up in there, Your Honor, and I want to address them. The first one is that it is true that there were some developments subsequent to the filing of the motion, and Mr. Washington addressed those. However, the court pressed him on whether, before trial, including after the filing of the motion, in that whole pretrial period, if counsel had consulted with him and discussed strategy in a meaningful way and given him discovery, and Mr. Washington confirmed that before he was in court, counsel had not done so. Counsel then got up and said, in response to the court's question, I'm sure I did discuss strategy with him. I'm sure I did give him all the discovery that I had. And the court, in making its decision, did not find those accounts consistent. It found them inconsistent.
The court also said that it observed that the defendant had discovery present with him, the documents that he was complaining that he didn't get.
You are correct, Your Honor, that at the that the court did say, I observed you coming in with discovery, but after he heard Mr. Washington's account, he felt it necessary to go to counsel and get counsel's version of events.
Yeah, but counsel, what's bothering me is what Judge Piggott was talking about before. Even if you don't say in such bold terms that the defendant lied, you mean the counsel is not able to say, put it, let's say he put it in a bow in the sweetest, most wonderful way, that, gee, I met with him last week, and then I met with him 2 days later, and we spent an hour and a half. Counsel can't say that if that's, in the counsel's mind, the truth?
He cannot say that unless the court appoints new counsel.
So what can he say?
So aren't you putting an ethical dilemma in front of a lawyer to say, my client is lying to this judge. He's flat out lying. But counsel tells me I can't correct that. And so I have to let this lie to a member of the judiciary be on the record. And I'm either going to stand moot, or I'm not going to bring in the proof that I have right here because counsel says I can't do that.
No, Your Honor. What I'm saying is that the court should approach these situations in a situation similar to as it did, for example, in Baroa. Baroa is an example where the defendant had offered testimony that it seemed to his own attorney was a lie. Leading up to the trial, there was no indication that the witnesses had alibi testimony for the defendant. And then they got up and gave alibi testimony.
That was a different situation. The counsel could be a witness on that issue in relation to the alibi. That's not what we have here.
Well, Your Honor, I think the principles announced in that case are closely analogous. There was a situation where a defendant could be perjuring in front of the court, and defense counsel had information to the contrary.
Clarify the process you're recommending, if I'm understanding you. You say at the point when counsel realizes that they are conflicted, that is to say, they will have to look the judge in the eye, and if they're not saying it's a lie, they're going to say, no, I did this, 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 and this, or in this particular case, when they're asked, would you have adopted this motion, and he says no, which is basically saying I can't support any of the allegations in the motion. At that point, he's got to, or he or she, what does the attorney have to do if you're saying they cannot respond to these questions or they can't on their own volunteer this information?
Your Honor, I think that one of the things to keep in mind is the reason that we were stuck in this situation in this case is that this was a pretrial motion, where, as you pointed out, they were complaining about.
I'm sorry, counsel. We're asking these questions because this isn't just this case. There are a number of cases. There are a number of trials going on as we speak in criminal courts where counsel will have these allegations, will have to face these allegations, and the courts will have to do something about them. So are you saying that every time a defendant makes an allegation against or that suggests that his lawyer didn't do something or her lawyer didn't do something, that the lawyer, as an officer of the court, has to stand mute or say to the judge, Judge, I think it's time for you to appoint another counsel, and that the court should have counsel essentially standing at the ready, because that's what we would need, to have counsel at the ready for every time a defendant made such an allegation against his counsel or her counsel?
No, I'm not saying that. And you're right, Your Honor, this does go to cases all over the court. When a court is confronted with this motion pretrial, first of all, most of these pretrial motions will actually be received pretrial when the court has an opportunity to address the alleged deficiencies before they can ever prejudice the actual trial. The court can look at the allegations and say, okay, yeah, it says ineffectiveness, is it really just a strategic disagreement? In that case, there's no real ineffectiveness claim. There is serious claim.
Assuming the judge says, yes, okay, those things happen, when the point that you're being asked about is if defense counsel knows for a fact, because they know what they have or have not done, that it's not an accurate representation, please answer my question. What is the process you're recommending, which is the same question Judge Abdus-Salam is asking?
The process I'm recommending is that if the defendant makes a claim of ineffectiveness that the court takes seriously and the counsel knows it is a lie, and that in order to give his account, he needs to get up and give a contrary factual version of events.
Yes.
He needs to say, court, please appoint a new lawyer to resolve this issue.
So that's what should have happened here. That's what the lawyer should have done here?
Yes.
Rather than answering the questions, he should have said, it's a conflict situation, you've got to appoint somebody else.
Yes, Your Honor.
Okay, counsel, you'll have rebuttal. Let's hear from your adversary.
Good afternoon. May it please the Court. Mark Ada for the Respondent.
Is that practical, by the way, what your adversary suggested?
Not at all.
Why not?
If we were to implement that, the judicial system would come to a grinding halt.
So what's the rule? What's the rule in your mind?
The rule is that an attorney under these circumstances, when these commonplace allegations of ineffective assistance of counsel that are frequently made immediately before trial are made, defense counsel should be made or allowed to give a brief defense or just outline of their
Defense counsel can't say, judge denied a motion, right? That you can't do.
No, and I don't think that's necessary under these circumstances.
Where do we draw the line?
Where do you draw the line? The line is, well, with respect to what? When they're taking a position on the motion?
Too far, yeah.
Well,
I mean, if they're contradicting what the defendant is saying, you're saying that's not enough.
well, first of all, as a factual matter in this case, our position is there is no contradictions whatsoever, specifically because of the sequence of events in this case.
But assuming that there were.
Assuming that there were, I think when there are allegations of failure to turn over discovery or failure to meet with a client, those are things that a defense counsel can contradict their.
How can't they contradict?
Well, for example, in the case that my adversary cites, Baroa, in that case, the defense counsel testified against their client, effectively eviscerating their case.
Did counsel go over the line here when asked, would you have adopted the motion?
Not at all. And I don't even think my adversary thinks that's inappropriate. A defense counsel has no obligation to adopt his client's motion.
That's not reflecting the counsel's position on whether or not there are inaccuracies in the motion or the motion is without merit.
No, I don't think it can be read that way. I think I can't recall the case offhand, but it's perfectly appropriate for an attorney to do that. And
is there a different standard post-trial?
with respect to what type of motion? With a reassignment motion, a 330 motion, a plea withdrawal motion?
Yeah, a withdrawal motion or a motion to set aside the verdict.
I can't imagine why. I mean, particularly, it really is a question of the types of allegations that are being made. And I guess in the sense that after a trial has been had, the allegations are going to have a different substance.
There are some circumstances where it would be appropriate, right, for the counsel to say, Judge, you know, I think you should appoint a new attorney, right? Sometimes the lack of trust, the nature of the particular allegations would be such that it would be appropriate for counsel to say, get me out of here?
Certainly, but that was not the case here.
I understand, but you acknowledge that there are times when what your adversary is saying is a good thing for counsel to do.
Right, but 98% of the time, these types of allegations are found in a pro se, pro forma, boilerplate motion that's found in
Yeah, but that's making a judgment beforehand that usually it's false. Let's assume that sometimes it's false, sometimes it's accurate. We're trying to make a rule that would apply in all the different situations of this kind where the defendant challenges his counsel in terms of the representation and the quality of the representation and what they're doing. So across the board, the rule is generally counsel can answer the particulars in terms of what he or she did or didn't do.
Yes.
But what can't they do? They can't say deny the motion. They can't say my client's a liar, or can they?
I think it would not be advisable to say that my client's a liar or that this motion should be denied, but they can make factual assertions about their representation.
So they should explain what happened.
Yes.
And in New York, if you have a difference over material conflict, a material fact, is that an actual conflict and then there's a real problem? Or it's a fact, but if the defendant has it wrong, you can just say, gee, Judge, this is what happened. You can explain what happened.
Well, what do you mean by material fact in this case? For example, if the defendant says, I didn't get my discovery, that is a perfect – I don't think that that's a material fact. This is a perfect opportunity for the court to resolve a situation like that without any undue delay. Defense counsel's proposition is that –
the defendant's saying, I didn't get it. Counsel is saying, oh, yeah, he got it. Isn't that a disagreement over a fact that works to the disadvantage of the defendant himself?
It certainly doesn't affect his guilt or innocence. You know, he's not going to be found guilty or found innocent as a result of the fact that he –
Okay, so your rule is if the counsel just tells the truth in an appropriate manner that doesn't demean his client, but that's okay because you're explaining what happened. That's the rule?
Yes, and it's the same rule that you propounded in Nelson in 2006, that a defense counsel's explanation of his performance, it does not create a conflict.
Well, yeah, it's the way I understand it, and I think Judge Lippman's totally right. It's a 98% rule, but those 2% matters if you're one of the 2%. But it seems that there's a difference between counsel responding to questions regarding his or her representation or the efficacy of the representation and counsel becoming a witness in the case at bar. And I think that's the broad line distinction that has to be drawn. There are obviously a million subtleties, but it seems to me that that's what we're confronted here, whether there should be a black line rule or we have to look at each one individually. So.
Right. And in a case like this, as you said, the defense attorney is not becoming a witness against his client. He's making informal remarks about his representation.
Well, you could argue that he's becoming a witness in the sense that he's speaking against a motion that the client made, and the client may think that that's in their interest. But that's not the issue that's at bar, the underlying case that's at bar.
Exactly.
So he's addressing his representation, which is a little bit different. Right.
So should counsel say, well, I don't agree with what he's telling you, this is what actually happened, but I'm not saying you should deny his motion. That's okay.
Yes, I think the attorney should be able to say, I did turn over a discovery or I have met with my client, and leave it at that.
Okay, counsel, anything else?
Nothing else. If there are no further questions, I rest on my brief.
Thank you. Rebuttal, counsel.
And going to the Court's question about the potential for abuse, lying about ineffective assistance, the same could be said in Mitchell, which concerned attorney coercion. In that context, a defendant can just as easily make up those allegations. Yet in that case, this Court announced the rule that while, yes, defense counsel can explain his performance, he may not do so if it means adopting a position adverse to his client. Certainly, I think we can all agree that the potential abuse by a few cannot nullify the constitutional right for everyone else.
Counsel,
And
can you posit a case where defendant makes an allegation and it wouldn't, and an explanation by his counsel or her counsel would not be adverse to the client?
Yes, Your Honor. For example, a defendant may file a motion saying, I'm making an ineffective assistance claim. And he says, my attorney did not raise this argument I wanted him to raise, like I'm incompetent to stand trial. That is an undisputed fact. The court will know, yeah, he didn't make that decision. So counsel can explain his performance without contradicting his client. He can explain this is why I did it, because his client has placed those decisions at issue. Also, perhaps, defendant...
That could be much more serious than the ones you were talking about before, though, couldn't it?
I'm sorry.
In giving the explanation, you can say, he says he's nutty as a hoot owl, and I think he's saner than the judge. I mean, that'd be awfully adverse to a client, would it?
Yes, that would be adverse to a client if, in his explanation, he adopts adverse positions and disparages his client. No, I would not say that that's okay.
So if he says, I want a psychiatric exam, the lawyer can't say, I'm not, I disagree with that because I've been talking to him for the last 6 months and he's been fine.
That is definitely more, I think that presents a difficult question, Your Honor.
But that would be really adverse to his client. Under your theory, that's adverse. The guy's saying he's nuts, I'm nuts, I want a psychiatric exam, and his counsel's saying he's not nuts. Isn't that, under your rule, a classic example of saying something adverse to your client?
Yes, Your Honor. I agree with that. I do. Yes. And another thing I wanted to address is that my respondent raised is Nelson, which is that Nelson did not purport to announce a categorical rule. It said that in that case, client's remarks did not create a conflict. But if you look at the underlying facts of that case, the comments that were made by counsel played no role in the court's decision. There the court said, I deny this because it's the eve of trial. You're raising this motion literally with the jury outside of the door. This is a transparent delay tactic. And that's a classic ground under this Court's precedent on which to deny a reassignment motion. But that's not what the Court did here.
Even that, because I thought at some point you'd raise the idea, because it always comes up, is alibis. You're going to trial. You're representing the defendant. The defendant says, by the way, I got a twin brother in Ohio, and it was him, that wasn't me. And it's nonsense. Now, what are you supposed to do with that? He goes into the judge and says he won't call a witness that I need.
If the defendant says he won't call a witness that I need who has an alibi, and the lawyer knows that that is false, no, he cannot factually contradict his client. He needs to ask the court to appoint new counsel. And that's a situation, actually, that is somewhat analogous to Baroa and demonstrates why the basic principles apply in all these different contexts. They apply.
You were saying earlier, if it's on the eve of trial, it's obviously bogus, then you dismiss it without further ado.
Yeah, trial courts, Judge, I believe, are very well equipped to apply these standards. We see in many of the cases that they handle these claims without resorting to a credibility determination between defendant and the client. They say, this is a strategic disagreement. This is a transparent delay tactic.
Did you get the impression, though, that the judge in this case was totally discounting what the defense did and totally credited whatever the lawyer said?
Yes, Your Honor.
Without a hearing. Yes,
Your Honor. That was expressed in his ruling. He said, when he moved to the merits, he said, based on what I've heard from you and counsel, I don't believe you. I accept what Mr. Spellman says. The things that you say are not true. And he expressly contrasted the two versions of events. He said counsel says you did get discovery. You say he didn't consult with you on strategy. He says he did that. And he said, I believe what counsel says. It really couldn't be more expressed that the Court's decision here rested on a credibility determination. And in that situation, he has rendered an adversary to his client.
Okay, counsel. Thank you.
Thank you.
All right. Let's go to Lovett. Counsel, you want any rebuttal time?
Yes, Your Honor. 2 minutes, please.
Okay. What's different about your case than the last case, and what's the rule in relation to what we've been talking about in Washington?
The rule, I think we urge, is similar, that where an attorney makes materially adverse statements refuting factual allegations and the court relies on those representations, there's a conflict of interest. But these are different cases in that I would say that Mr. Lovett's allegations of a conflict went not just to whether or not documents were turned over or communications, but went deep into the heart of the attorney-client communications that they had about.
Like any of these allegations about conflict when you were, when your client was complaining of ineffective assistance of counsel, did you say that, or did he say, counsel say that he was entitled to conflict-free counsel? Did you even bring up conflict at all?
We didn't bring that up below. What we raised in the appellate division was focused primarily on the appellate division's broad equitable jurisdiction.
Is that a big problem for you, that you didn't bring it up below?
Absolutely not. Because we made a strategy decision there that this is a case that was really crying out for the appellate division's equitable interest of justice jurisdiction to reduce the sentence or to impose a determinate sentence, given that the court was clearly biased against Mr. Lovett below. And I would refer to page 671 of the transcript, where the court said this case has been one baby whining, crying on your part, saying on page 673, if there is a parole officer, if there's a parole board, whoever thinks there's a reason to release you from jail, they should be fired. You are sentenced as best as possible to die in jail. So we didn't raise them below, but they are properly before the court, and we are asking this.
Why are they properly before the court now, if you didn't preserve it below?
Because the deprivation of the right to counsel doesn't need to be preserved, and statutorily things don't need to be raised in the appellate division to be raised before this court. Even respondent doesn't claim that this court does not have the power to hear this claim. You know, in hindsight, obviously we should have raised it before, but here there were serious complaints made both prior to trial and before the sentencing proceeding. And going to the conflict, since Your Honor asked about that, not only did it go to the heart of the communications between Mr. Lovett and his attorney about whether or not he'd spoken about whether or not there were other witnesses, whether or not counsel had received that information. Here we do have a situation where the conflicts clearly spilled over into the sentencing, and there were a lot of questions about what can counsel say. I think Mr. Lovett's case is a clear example of what counsel can't say. Counsel piled on here. He filed an affirmation prior to sentencing. He amplified it at the sentencing proceeding. Even after the motion had been denied, when he was supposed to be arguing for leniency, he said that the allegations in the motion were ludicrous. So in tone and tenor, his statements were completely adverse to his client. In terms of the fact that the motion had already been denied and he continued with it, they were gratuitous and uninvited at that point. He had abandoned his role as an advocate. He relied on matters that were outside the record, confidential communications, and even if he didn't say this motion should therefore be denied, it couldn't be more clear. And this is a case where counsel, as demonstrated in the motion for resentencing, could have made very substantive arguments on Mr. Lovett's behalf in terms of leniency, but you can't make those arguments to a court when you're saying, you know what, here's my arguments for leniency. First of all, he's a liar, but I'd like to give you, like you to exercise leniency here. Mr. Lovett had worked, had involvement in his church. He had community involvement.
But counsel did make those arguments to the judge.
He didn't. We would actually disagree with that. Counsel made the most tepid of statements. He said he has children. That's all he said. And he misstated how many children Mr. Lovett's wife had actually fathered, or said Mr. Lovett only fathered 2 of the 3 children. He didn't raise arguments that Mr. Lovett had tutored his son and niece, that he had all of his family members said that he was very active in their life. If you look at the resentencing motion, it shows he had, I believe, 11 letters from family members attesting to the role that Mr. Lovett had played. So this is a unique case in that the counsel's statements, even if you can say something, went so far beyond that there was a conflict of interest, and the case does need to be remanded at the very least for a new sentencing proceeding. And Mr. Lovett's complaints at sentencing, I do want to address briefly one thing that wasn't raised in the other case, is that he had made a motion even prior to trial saying that his attorney had failed to investigate. And that motion was improperly handled. The court told him that he could not make a statement. At first, pages 47 to 48 of the appendix, 3 times told him not to say anything.
But then he let him say whatever he wanted to say.
The court did allow Mr. Lovett to speak, but if you look at the actual record, the court did not change its opinion that the motion was untimely, and I direct your attention to page 51 of the appendix. As I said, if there was any possibility that a motion were going to be made on that subject, it should have been made in Justice Uviller's part. The court also said, I don't know what he has done by way of preparation. I don't know the contacts, if any, he's had with you. I don't know what investigation he's done. So this is very different than Porter. You have hostility to the motion being raised at all, no questions in Mr. Lovett. The court's admitted ignorance as to whether or not they had been communicating or an investigation would be done, and in the end, denial on improper timeliness grounds, which is contrary to this Court's decisions in People v. Linares and People v. Sides, saying that there is an ongoing duty to look at these. And I also would finally like to point to the extremely extenuating facts in this case. I know that the timing of the motion right before trial might in some cases be a red flag, but here you have a case where Mr. Lovett had plummeted 60 to 70 feet to the ground. He was severely injured. He required 4 surgeries. He suffered memory gaps. He was sedated in hospital.
Counsel, when did he leave the hospital? It was months before the trial, wasn't it?
It was either at the end of January or beginning of February of 2003. The trial was May 22nd of 2003, but there were only a handful of court appearances in the intervening time, and certainly this Court shouldn't suggest a rule that his problems with counsel need to be raised at the first possible opportunity. What happened here is that once the case went out to trial, once it became clear that his problems weren't being addressed, he asked the Court for new counsel. The Court discouraged it, and to the extent that there aren't as many factual allegations as we would like, the onus falls on the Court, which discouraged him from even making the motion.
Don't close up yet.
Judge Fahey, go ahead.
Don't close up yet. Listen, the third point, I think, in your brief was a failure to object to the jury charge.
Yes, Your Honor.
Was that raised at the appellate division?
It was raised in the appellate division. It was raised both in the CPL 440-10 motion and at the appellate division, Your Honor.
Okay. Thank you, counsel.
May it please the Court, Nicole Caviella for the people of the State of New York. Beginning first with the conflict of interest point, I think that this Court established a very clear rule in Mitchell.
How can calling your client ludicrous, client's allegations ludicrous, not be a conflict?
Your Honor, that comment was a factual characterization of.
It sure was.
It was a factual.
At a point in time when you're asking the Court to give your client leniency.
Well, Your Honor, the only reason that defense counsel revisited the issue is because defendant himself renewed his motion and again reiterated the allegations, suggesting that his attorney had not.
Assuming that counsel was permitted to continue to respond to those continuing allegations, can counsel?
Yes, and of course, and Your Honor.
So then where is there a line at all? Is there anything that counsel can't say?
Yes, of course. This Court stated in Mitchell that defense counsel is permitted to explain his performance. He is permitted to defend that performance until he takes an adverse position on his client's motion.
Calling your client ludicrous isn't taking an adverse
He was not.
position?
He did not call his client ludicrous. He
ludicrous.
called a very specific factual allegation, Your Honor, where defendant repeated not only in his affidavits but also when given the opportunity to speak at sentencing, repeated again and again that counsel had not consulted.
He has to say the magic words, "My client's motion has no merit." Is that what happened? Is that what's required?
He never said that his client's
his motion has to happen in order to create a conflict.
Yes. Actually, Your Honor, I am saying that the counsel, as this Court made clear in Mitchell, in DeLezer, in Glynn, in Vasquez, defense counsel has to address.
What part of the motion remains meritorious if you've said it's ludicrous?
He hasn't said the motion is ludicrous.
So the allegations of
He specifically, he's characterizing defendant's allegation that he never consulted with him. And defense counsel says that right after
Isn't that the equivalent of saying that allegation is without merit?
It's saying that what defendant is alleging is not correct. That is no different than what the defense counsel did in Nelson when defendant alleged that he had, not actually described the charges against him. Defense counsel says you're mistaken.
It's just a little bit more than just it's
a strong word, Your Honor, but at the same time, he's, again, this attorney.
Unmoored from reality is what it's suggesting, no?
No, Your Honor, this counsel was simply trying to put across the point that his client's assertions that he had not consulted with him were incorrect. Okay? It was a strong word, but at the same time, he's still addressing a factual – he's still making a factual statement. At no point –
I want to slow down. I want to go to the jury charge question because
Yes, sir.
This same jury charge was subsequently overturned, wasn't it?
No. It is a different charge that was given in Johnson, and that was a year after.
Slow down.
I'm sorry.
Slow down.
I
Let me ask my
apologize.
question. And I'll let you –
Okay.
Don't worry. I'll give you some. Explain to me the difference between the two, because they've been characterized as the same charge. Go ahead.
Okay. So in Johnson, the court gave a two-inference charge that included language that essentially said that when you're finding facts, the burden of proof is 50.1 beats 49.9. The court did not use that language in the two-inference charge it gave here. And moreover, it couched the two-inference charge with a statement that the jury was required to give defendant every reasonable inference, that defendant was entitled to that.
So
that language – I'm sorry.
Your position is then that the charge itself that was given by the court was correct?
Yes. It was,
so
and
it wasn't,
has been
so therefore then it wasn't ineffective assistance of counsel not to object?
Exactly, Your Honor.
I
That's
see.
our position on the jury instruction. Just turning back quickly to the conflict of interest point, there it is. This Court's decisions in Friedman and in Nelson and in Mitchell demonstrate that a defense counsel is allowed to make factual statements that contradict his client on the record, and that in doing so they do not create a conflict of interest. In Friedman, the defense counsel, defendant was moving to withdraw his plea on the ground that he was under the influence of truth serum at the time that he was that he pled guilty. And his attorney said to the court, he appeared well to me on the morning he gave the plea, and his examining psychiatrist who administered the truth serum said it was unlikely he was still going to be adversely affected at the time of the plea. The court relied on that defense counsel's statement in denying the motion without an evidentiary hearing. And I think that demonstrates that it is perfectly appropriate, and in fact, counsel has an obligation to prevent his client from misleading the court. I've just turned very quickly, Your Honors, to the motion for substitution of counsel. In Ariave, this Court said that the trial court should be particularly skeptical of motions that are made on the eve of the trial because they implicate serious consideration, public policy considerations against delay, and that absent a demonstration of compelling or exigent circumstances, the court can deny them. And here, defendant, after nearly 8 months of representation by counsel, had apparently never voiced any sort of dissatisfaction with him. And then the minute the trial judge calls out for a panel, a jury panel, all of a sudden he's making a motion that is completely generic and conclusory. The only thing that was arguably factual in it is that he said that he had not seen his attorney he had only seen his attorney once in court, and they had not had a conversation, but that was belied by the record. Parties had just been discussing with the court the history of plea negotiations in this case, which counsel had obviously related to defendant. Defendant had rejected.
Counsel, can I return to the allegations of conflict?
Yes.
It's my understanding that the affidavit that was submitted in this case was submitted by defendant's wife, not by defendant himself.
The defendant himself filed there were 2 affidavits by defendant and 1 by his wife, Charlene Braithwaite. Defense counsel himself did not, contrary to what defense counsel has said, did not file his affirmation before before sentencing. He had it, he brought it with him, and there's no indication that he would have filed that unless the trial court had not asked him for comment.
Well, my question concerns the affidavit filed by the wife.
Yes, Your Honor.
That counsel essentially did a line-by-line recitation or explanation or refutation of. How does that impact the conflict for defendant if it's the wife, not the defendant himself making the allegations, or does it matter?
Well, I think just in a general, again, I think it's entirely appropriate for the counsel to make specific, refute those allegations if they're untrue. But I think that in the law.
Even if the position that counsel's taking is adverse to the client?
Well, again, I think that this Court has delineated the difference between taking a position that's adverse on the actual motion and contradicting factual allegations made by a client that may be misleading or untrue. And I think that in the general sense, like in the broader conflict arena, when we're discussing instances where an attorney actually takes the stand and testifies against his client, such as in Baroa, in that instance.
So is it your position that every factual refutation of an allegation cannot be, or there are no factual refutations that could be adverse to the client?
In the context of an ineffective assistance of counsel claim, I don't think so, Your Honor. And I think that Nelson demonstrates that fact. In that case, the attorney contradicted and refuted every single one of the allegations that that defendant and defendant's brother lodged against him, and at the end opined that he had actually been effective in his assistance and provided excellent counsel, and this Court still didn't find that there was a conflict of interest. What happened here did not even was nowhere near what had happened in Nelson. If there are no other questions, we'll rest on our brief. Thank you.
Thank you. Counsel, rebuttal.
Yes, Your Honor. In regard to Judge Abdeslam's question, there's no distinction between the affidavit submitted by his wife. It was submitted in support of the motion, and it said that she had provided counsel with information about potential witnesses who could have cast reasonable doubt on whether or not.
What if the attorney doesn't realize that a motion has been filed? He just gets the affidavit, as the attorney said in this case. Didn't even know that a motion had been filed by his client.
He did know that a motion had been filed by his client. What he didn't know that the second motion had been filed by his client. So there was actually Mr. Lovett filed the motion to set aside the verdict, which had his wife's affidavit in support. Then there was another motion that was submitted afterward that he hadn't read, but he had clearly received the motion by Mr. Lovett. He had read it, and he filed a written affirmation saying that what Mr. Lovett's wife is saying, that is being said in support of the motion, is not true. They never told me about that. And then on page 650 of the appendix, what's in her sworn affidavit are things that we had never talked about. So there is a clear conflict of interest here. This is different than Nelson, where this Court didn't even go into the underlying facts, but the appellate division definitely found that the statements by counsel were not even relied upon on the Court. And there it was things like whether or not a plea negotiations had taken place. Here, it's whether or not an investigation has taken place. And again, you're just repeating that, you know, if there's ever going to be a situation, and we stridently suggest there should, where factual allegations cross that line, this is one in terms of tone and tenor, in terms of taking every opportunity to pile on. And really, most strikingly, I don't think I've ever seen a case where after the motion has been denied, counsel is still defending his reputation and not representing his client.
Okay, counsel. Thank you. Thank you both, all of you.